We're going to have to start, of course, with this Abby Zwerner case. We've been covering this trial extensively here on MK True Crime. It's a case that our audience has told us that they really want to hear more about. But before we get into it, by way of reminder, this was a 2023 case. In 2023, a first grade teacher by the name of Abby Zwerner, she was shot by her 6-year-old kindergarten student. This despite warnings that went unheeded by school administrators that the child had a gun with him and was possibly dangerous. Abby has sued former assistant principal Ebony Parker for $40 million, and we have just learned the outcome of the trial yesterday. Let's take a look and listen as the jury returns its verdict.
Madam Clerk, will you please read the verdict?
We, the jury, on the issues joined, find in favor of the plaintiff, Abigail Zwerner, and assess her damages at $10 million. The award interest beginning on June 1st, 2024.
Thank you, Madam Clerk. Thank you very much for your service. It is an important service to all of us, and I know it has been a difficult service, but one that is necessary for the resolution of disputes in this country that I am very proud that we get to exercise those rights. Ladies and gentlemen of the jury, you are excused.
All right, Mark Geragos. After, let's see, over the first 3 days of testimony, this 7-person jury heard from 16 witnesses called by Zwerner's legal team who described the events as how they unfolded that day, and they talked about the toll that it took on the teacher, who, by the way, is still carrying that bullet inside her body. Mark Geragos, was this the right verdict, and was that the right amount?
Well, it's about 1/4 of what they asked for, if I'm not mistaken. And I as a lawyer who does trial work and plaintiff's work, I always want to know. I have friends who get large verdicts, and sometimes they get the large verdicts and they're not collectible. Who is paying, or theoretically is paying for this, is my first question. Because before I say, is it the right verdict, I want to know if there's somebody. I mean, it's one thing to get the verdict, and I know for lawyers, sometimes you use that to kind of to show your skill set. But ultimately, at the end of the day, is this collectible, is my question.
Well, you know, Dave, that's Mark raises a very good point, because they say you can't get blood out of a turnip, so to speak. And this defendant in this case, you know, she's facing criminal charges of her own. She's got charges pertaining to child neglect, and that case is due to go to trial next month. I mean, is there insurance here? Does she pay this out of her pocket? Dave, you're the expert on all things involving civil liability. So tell us, who's going to pay for this?
Well, thank you for making the expert of all things. That's a new title. I put that on my epitaph.
Yeah. Phil just qualified you. I'm going to find. I'll submit on that.
No, please. But apparently, it's interesting that now Abby Zwerner has the incentive to hope that the defendant here is found not guilty of the crimes, because if she's found guilty at her upcoming criminal trial, then that gives an out to the insurance that is involved that could pay part or all of the amount to not pay at all if you're found guilty of a crime. So it's a very interesting situation now where she won the civil case, which went first, which is unusual because usually the criminal case goes first, but this apparently was a strategy of the assistant principal to put the civil case first and maybe show the hand of the witnesses against her. And now Abby Zwerner has some different motivations than normal victims, saying, yeah, maybe if she's not found guilty, I'll get paid, because there is a fund for these types of situations that she could get paid from, but it's less likely if the assistant principal is found guilty of a crime.
Well, you're referring to the Virginia Risk Sharing Association, which, as you mentioned, that's an insurance pool made up by public bodies statewide, which includes the Newport News School Board. But see, the insurance company has an argument to be made here, I think, that, look, if this person is committing a crime, normally, you know, insurance doesn't cover criminal acts, right? But this is more like a gross negligence kind of thing. Mark Geragos, do you think that the insurance company would be off the hook because she's also accused of a crime?
So this is an interesting issue from this standpoint. In California, for instance, there are two code sections that even if you're charged with a crime, you can make a claim if the crime is for something you're doing in the course and scope of your employment, so to speak, that you can then kind of lay claim to the employer. The employer has got to reimburse you. I've done that a number of times. The other nuance here is, was the lawyer, the defense lawyer, being paid by the insurance company under what's called a reservation of rights, where they say, okay, we're going to provide you a defense, but if it turns out that you get held liable for some act that takes you outside of the policy, and generally, as you've noted, Phil, that's a intentional act, generally will take you out of a coverage for negligence, then at that point, they've got a way and something to fight with. Then you've also got, on the criminal cases, you've said, if there is a conviction criminally, that could then say, okay, then that fits into the reservation of rights and we're not going to pay, and a criminal act is outside the scope. Look, it's tough enough to collect with insurance companies as it is when you did nothing. Just imagine when you're found liable for something, how tough it's going to be to get the insurance to pay.
Well, you know, you would think that the deeper pocket, so to speak, would be the school system, but we have things called sovereign immunity in the United States, and so it's oftentimes very difficult to sue and collect judgments against government entities unless the particular state in question has passed a law that would waive sovereign immunity in certain kinds of cases. But speaking of the lawyers on the case,
well, by the way, Phil, that's a great point, because they passed a law in California that kind of a look back law for sexual abuse. Interestingly, it started to kind of snowball, and now they want to not only sunset it, but exempt municipal, like the county or somebody running the probation department, or somebody who has a dispatcher who's out of control, because all of a sudden these abuse verdicts or large verdicts end up potentially pushing these municipalities into bankruptcy. And now I think one of the look back laws that's making its way through California, even in California, they're starting to exempt the municipalities.
well, I don't know all things related to sovereign immunity, but I did write a law review article about it when I was in law school, and it goes back to Old England, right? The English common law, where it was said that it's just not right, so to speak, to sue the king in his own courts. And of course, we don't have kings in America, and we have a different legal system, but that idea, along with lots of other things from English common law, has filtered its way into our legal system. But I wanted to talk real quick about the attorneys in the case, because the attorney for the plaintiff, Kevin Beniazin, I guess is how I pronounce his name. My apologies to Kevin if I mispronounced it. But, he has argued that the defendant Parker failed to act despite multiple warnings. Now, so that the question is her failure to act, is that an intentional act so that it would throw it out of insurance coverage, or is that some kind of negligence? I think if we can roll SOT 6, we have this plaintiff's attorney in his closing argument arguing that the threat was very real and that it was ignored.
All this talk about we didn't think it was a real threat, it wasn't a credible threat. Why are you agreeing with Ms. Kovac to search the bag if you don't think it's real? And when they say, did you search the person? And the response is, we already checked the bag. Guess what that tells us? We thought it was real, and we don't know where it is anymore. We don't know where it is anymore. And then the boy outside of Miss West's classroom crying, remember? Crying, not wanting to go back into Mrs. Z's classroom where he's supposed to be. Says bullets and shoot. The boy showed me bullets, JT showed me bullets, and he said if I told anybody, I would shoot. Bullets, shoot, gun. The only way you can shoot a bullet is if you have a gun.
All right, Dave, obviously, I mean, if we weren't talking about a 6-year-old, we could invoke the saying, triggers don't pull themselves. It had to be, an intentional act. But children, especially at the age of 6, we don't impute criminal liability. But clearly, the child intended to shoot his teacher. But the question is, did the administrator intend for that harm to occur, or was she merely negligent? What do you say?
I don't think that anyone would say that the assistant principal intended the harm to occur, but she was pretty much reckless in my mind, even worse than negligent. I mean, she knew the history of this 6-year-old. This 6-year-old has in the past engaged in violence, strangled a different teacher. This 6-year-old grabbed Abby Zwerner's cell phone before this incident, days before, smashed it on the ground. He pulled up the skirt of a girl in class and felt her up. And because of his misbehavior, his parents were required, at least one of them, to be in school with him at all times. And the week this happened, the week this tragedy occurred, his parents were not there. So the assistant principal knew what's going on. And instead of saying, let's deal with this, she actually ordered the staff at the school and the teachers not to touch this kid, not to do anything. Let the parents come and show up. Don't do anything. So this is worse than just negligence in inaction. This is actual action to protect this kid at the expense of Abby Zwerner and others who are put at risk.
Well, because we are fair here at MK True Crime, and we like to give both sides of things, we've got SOT 7 here, which is the defense lawyer Sandra Douglas, in the closing argument and referring to witnesses who may have inconsistent testimonies or inconsistent statements throughout the case. Let's roll SOT 7.
Which Amy Kovac to believe? Try this one. Amy Kovac's text to Dr. Parker 2 days after the incident. Look at this. Amy Kovac to Dr. Parker. You are an amazing person and educator. No one could have ever predicted this. We all did our best. We did what a true teacher will do in this situation. Be there for our children in school. As I look back, I should have sent JT out of the room with a note and a job to deliver it around the school. And I could have gotten that book bag, but I didn't. We can't look back. We can only move forward. I love you and I'm proud to work with you. But that Amy Kovac didn't come to trial. She sat here and she threw shade at Dr. Parker. She dissed her work and she threw shade, not this Amy Kovac. Remember that.
Well, I do like her style. I do like that style of a passionate closing argument. The Amy Kovac that she's referring to, Mark, she's the one that referred to, well, she talked about Parker dismissing the gun in the pocket because she said he had little pockets. Because I know this is something that you want to talk about. But before you do that, let's roll SOT 8 so we can see what Amy Kovac said.
What do you tell Dr. Parker at this time?
So again, I tell her that I went and checked the bag. I told her just what I said to you all, what was in the bag. And then I also tell her that Abby texted me that they were out at recess, that he took something from the bag and he put it in his pocket.
Did you tell her you thought it could be a gun?
I mean, I told her that I reported that it was a gun. I mean, the whole time I assumed she thought it was a gun because that's what the girls reported, and I went and reported to her.
And what did she say in response to you when you said he put it in his pocket?
She did say that, well, he has little pockets, and I said he put it in his jacket pocket. And I was kind of mad, and I walked away.
Mark, it seems like there's a different Amy Kovac when she's simply sending a message to her boss, maybe kissing the boss's ass a little bit. But when she gets in court under oath and she realizes that she has to tell the truth, maybe then that's when the truth comes out. What do you make of it?
Well, it's one of the reasons that the three of us make our living and put food on the table by virtue of cross-examination. It's an amazing thing what happens out of court and what happens in court. And that's one of the problems for witnesses, or it's actually one of the benefits, if you will, of the court system. Once you get somebody who has to tell the story and can be questioned and can't kind of shade it or round the corners to different situations. So I always opt for, in fact, the law is that you're to view with disbelief what is said out of court orally, and you're supposed to take what's on the witness stand under oath as the actual evidence. So I always lean, I follow that. That's the altar I worship at. So I vote for what happens in the courtroom after a vigorous cross-examination.